SwayamPrabha. Digital India. Educated India.
Welcome back to the course of Law of Torts, Consumer Protection and Motor Vehicles. This is the 12th lecture and we will be discussing trespass to property here. In the previous lecture, we discussed trespass to person and we also introduced the concept of trespass, and I mentioned that trespass can happen through various forms, and trespass can be towards an individual's body, and that we discussed in the previous lecture, assault and battery. Now we will discuss trespass with reference to property, and when we say property, property will be usually two categories. One, immovable property, that is property which is attached to the land. So land, house, buildings, trees, unless it is cut for timber, gardens, all this will be relating to farmland, all be relating to property relating to immovable property. So immovable property is categorized under trespass to land, and the other is movable property. Now movable property is considered as part of trespass to goods. So therefore we will study two types of trespass: trespass to property, trespass to land, which is basically trespass, a form of trespass to property but immovable property, and the second we will study another type of trespass to property which is in connection to movable property, which is called trespass to goods. In addition, there can be other types of trespasses: animal trespass, or which is called cattle trespass. Then there can be trespass to chattels. So there are different forms of trespass, but we will restrict our discussion principally to three types of trespass. In the previous chapter, previous lecture, we have discussed about trespass to body. Now we will discuss trespass to property, and with connection to property, with immovable property trespass to land, and with movable property trespass to goods. So these are the four topics that will be covered in this lecture: trespass to land, which is immovable property; ways of committing trespass to immovable property, that is trespass to land; then trespass to goods, which is movable property; and then with connection to trespass to goods, we will discuss one more very interesting tort, which is called tort of conversion. Now conversion is not trespass, it is a different aspect, tort of conversion, but trespass to goods and tort of conversion has many overlapping or similarly looking sort of characteristics. So we will understand this tort of conversion, and then we will distinguish tort of conversion from tort of trespass to goods, so that our understanding of trespass to goods is proper and we are not getting confused that whether it falls within the trespass to goods or trespass to tort of conversion. So that is why we will discuss tort of conversion. Finally, we will discuss what justifications a trespasser can provide when he is sued for trespass. So justifications for trespass, and I said that these justifications are more specific because the general justifications are already discussed in the general remedies in the 4th lecture. These are specific justifications which are allowed for only this kind of tort, which is trespass. So we start with trespass to land. Trespass to land or immovable property is one of the most oldest form of trespass. Now you have to understand that the whole human society has evolved surrounding two aspects. One is making our life better, bringing security to our life, and property. And when we say property, the most important aspect of property right is land, or landed property or immovable property. So therefore trespass to land is as old as a legal principle, as old as society. But it had different characteristic or different kind of an conception in the Roman law, slightly different in the Greek time. It has a different sort of understanding in the Indian, old Indian laws, and it has a different understanding in the common law. Now, these understandings may not be very different. Now, what the Greek and Roman law later was consolidated into the codes of civil law. So, in civil law codes we see the concept of trespass, and in common law trespass evolved largely through judicial decision. So, there are similarities in all our old ancient Hindu law or Muslim law also we see the concept of trespass. So, trespass to land is a very important aspect, because it is the natural right that a person has to hold his land, as he has a right to bodily safety, bodily integrity, that he also has a natural right from age old to have right and exercise control and enjoy the fruits of his own property or land. So, trespass square causam fegit. This is a Latin maxim to identify trespass. As I said, trespass exists in every law. So, trespass square causam fregit, when the defendant break in or enter into the land of the plaintiff. So, in Latin norms, this breaking of the defendant into the land of the plaintiff is regarded as trespass square causam fagit. So, trespass to land. What are the essential conditions of this trespass? There are three essential conditions. First is by entering upon the land of the plaintiff. By entering upon the land of the plaintiff. Second, by remaining there. Third, by doing an act affecting the sole possession of the plaintiff, in each case without justification. So, these three conditions are essential. Entering upon the land of the plaintiff. Trespass requires entry. If there is no entry, no trespass. And this entry has to be voluntary and without justification. If somebody throws someone into somebody's land, that is not trespass, because I was involuntarily had an entry to that land. I did not want it, but somebody threw me into that land or into somebody's pond. But when I entered the land with a voluntary decision of mine and without justification, then I am fulfilling the condition 1 of trespass. Second, after entering I remain there. Now, after entering, when I realize if I come back, that is a different issue, but after entering I remain there, and then I do something which affect the possession of the plaintiff in each case without justification. So, first I enter, second I remain there, and third I do something which affect the sole possession of the plaintiff. So, entry, remaining there, and affecting by my act the sole possession of the plaintiff. How is this possible? For example, this is my land and this is defendant's land. And there is no boundary wall here, they are adjacent. Now, I have some fruit orchards, some trees. And plaintiff also has some fruit orchards. Sorry, defendant also has some fruit orchards. Now, defendant saw that these fruit orchards were hanging some juicy mangoes. So, what he did? He entered into my land, plucked the mangoes and left. This is a trespass. Why? Because he knows that it is not his land. Therefore, he has no right of entering into that piece of land, but still he enters. So, and enters without any threat, coercion or anybody else asking, making him to enter. Purely by his own voluntary consent or voluntary self, he enters. And there is no reason why he entered. There is no justification on his part why he entered into my land. Then after entering, he does not leave, he remains there. And then what he does? He plucks those mangoes which are my property or in my sole possession and takes them away with him. Now, plucking the mango, up to plucking the mango, so first is trespass to land, then plucking the mango will trespass to not land, it will be trespass to goods, and then taking away with him is conversion. So, each one is linked and we will discuss that. So, entering into the land is trespass to land, we are right now concerned. So, there was an entry, he entered and this entry was without any justification and purely voluntary. Then he remained there and by remaining there he affected the sole possession of my property. Now, it is not that plucking the mango only this condition, he is remaining there, he is standing, that itself is affecting the sole possession of my property. Now, say there are two pieces of lands. And there are in this land B 3 big ponds. Now, A and B initially both belong to the defendant. Both this land belong to defendant. Then, by a lease agreement of 10 years, defendant leased this land B. So, B part by lease agreement he leased out to plaintiff P, and the plaintiff employed his servants so that to ensure that he has occupation and control and possession of that property. And then in these tanks, water tanks, he started culturing fish, pisciculture or growing fish. So, he invested and he was doing for commercial purpose, because the fish that will be cultivated from here will be sold in the market, and that was his purpose for taking this land for lease. Now, he was paying his lease and the property was very much in his control because he has raised servants. Now, one fine night, the defendant with his servant entered into the land under this justification that the plaintiff has not paid him the rent for the lease property and forcefully removed his servants and locked the door. Now what action it is? It is an action of trespass to land. Why? Because there is an entry and this entry is voluntary and without justification, because the lease agreement shows whatever rent the plaintiff has received that he is paying those rents. Even after that the defendant entered voluntarily, so therefore he does not have any justification, he and his servants. Then what they did, they forcefully removed the servants of the plaintiff, so remained there, and put a lock on the door which affected the sole possession of the plaintiff. So this is where trespass to land or trespass quare clausum fragit is constituted. There can be another example. There are two lands, A and B. A belongs to the plaintiff, B belongs to the defendant. Now defendant discovered by some way that in this portion of the plaintiff's land, which is adjacent to the defendant's land, so basically in this entire portion, part of defendant land also, there is a quarry of limestone, sorry not limestone, there is a quarry of bauxite. There is a huge deposition of bauxite which is underground and possibly plaintiff has no idea about it. So what he does is that now he starts a mining operation in his field. So he starts a mining operation in this part of his field, but he allows his miners to also underground dug tunnel and enter into this part of the plaintiff's land, and also to take bauxite ores from the deposition below the plaintiff's land. Question here, is any wrong? Yes. What wrong? Trespass to land. Why? Land does not mean only subsurface, it also below surface, anything belongs to the plaintiff. So defendant knowingly if entry without voluntary justification and remaining there and affects the sole possession of the plaintiff, it is a case of trespass to land. Now there is a wonderful question. To constitute a wrong of trespass, neither force nor unlawful intention nor actual damage nor breaking or enclosure is necessary. All these things are not necessary. You can just enter and remain there, but you have to affect also the position of the plaintiff. Then only trespass is proved. And damage is also not necessary, no actual damage. You have not done any damage to the land. Land belongs to me, there was no boundary, you entered, you pulled a camp, temporary camp and started living in the land. That is enough. You put a signboard in your name that this land is mine, that is enough. So no force, no unlawful intention, no actual damage is necessary. But if they are accompanied, then they become more aggravated form of trespass. But the interesting question is, if the defendant consciously enters into a land believing it to be his, but which turns out to be the plaintiff, whether it is a trespass. So he entered into the land involuntarily, whether it is a trespass. Now this question was asked in this case of Bulsley versus Clarkson in 1681, where the defendant mowed his own land and he mistakenly crossed the boundary and moved the land of his neighbor, believing it was his own land. The defendant's plea of mistake in claiming the trespass had the land failed. Why it failed? He mistakenly had entered. I said voluntary. Now in this case it is not voluntary. If you mistake, by mistake enter, although mistake of fact a mistake is not a defense generally, but it is limited, I said. In our general discussion, we said mistake is a general, mistake of fact when it is very, very apparent. But mistake of law is not a justification at all, mistake of fact in limited scenario. So, even if we get benefit that he mistakenly entered, but still why did the court ruled here that he committed trespass? Because it was not voluntary entry, the entry itself was involuntary. Now, the court saw the remaining parts of the facts. The remaining parts of the facts was that after entering, he mowed the land of the plaintiff also. So, he was mowing his land and then he entered mistakenly and mowed the land. Now, this is where the court held the trespass, because his entry may have been mistaken, but he was there and then he affected the sole possession of the plaintiff by mowing. So, his act of cutting the grass was intentional even though he made a mistake as where the boundary was. So, his act of crossing the grass was an intention and the boundary was maybe his mistake. But if the entry is proven to be involuntary, then it is not a trespass. So, only if the entry is involuntary and then he immediately leaves without staying there or without doing anything that affects, then in that case it is not trespass. Remember the story of Hanuman entering the Ashok Vatika in Ramayana. What he did? He entered to meet Lord Sita, Queen Sita. But what he did was, after that he entered into that Vatika and damaged the fruit bearing trees, ate a lot of fruits. That is trespass. Of course, he intentionally entered, but it can be still justified that somebody was imprisoned, so he went there with a statutory authority to meet him. If we say Ram is the statutory authority, Lord Rama. But after entering there, what he did, that is definitely a case of trespass. Now, in the previous lecture, we discussed nuisance, and there I said I will discuss the distinction between nuisance and trespass. There is a small error, it is a nuisance, NUI, so I is missing. So, I will discuss trespass to land and private nuisance difference in the discussion with trespass to land. So, what is the distinction between nuisance and private nuisance and trespass to land? First is, trespass is actionable per se. That means no damage is required. You entered somebody's land, you stayed there, and that is enough to say that somebody's property was affected, sole possession was affected. Now, we committed any damage or no damage, that is not necessary. It is a actionable per se. So, proof of real damage is not necessary. Torts which are actionable per se, the word actionable per se means that no proof of real damage is necessary. But nuisance is actionable only when there is a proof of damage. Trespass is actionable per se. Nuisance is actionable only on a proof of damage. So, first foremost distinction. Second, distinction lies in nature of the injury. If the injury is direct, it is trespass. So, the type of nature of the injury is a measure for whether it is an act in trespass or it is an act of nuisance. So, injury is direct, it is trespass. Where injury to the plaintiff is consequential, it is nuisance. What does this mean? Injury direct and injury consequential. Now, if you look at the example below, it says that if a person throws a stone on his neighbor's land, it is trespass. stone entry direct. Throws a stone into neighbor's land, it is trespass. But if a person plant a tree on his land, the roots of which after some years undermine the foundation of the neighbor's building, it is nuisance. So, I plant a tree in my land, but the roots of the tree now underground goes and causes damage to the foundation of my neighbor's building. Then there is no direct act. So, it is a consequential damage, but it will still be a case of nuisance. So, trespass is a direct act, whereas nuisance is a consequential nature. It is not that nuisance cannot be also direct act, but say for example, if my servant throws a bag of garbage into somebody's land, throwing the bag of garbage and the garbage landing in his land and remaining there is trespass. But the foul smell that it creates or attracting insects like rats, cockroaches, cats and the subsequent problems to health and hygiene will be nuisance. So, it can be an action for trespass and nuisance both. Now, as I said in my earlier example that when somebody without approval enters into the subsoil level of someone's land, it is a trespass. Similarly, if somebody goes above somebody's land and enters, it is a aerial trespass. So, what is an aerial trespass? The rule is that owner of a land is entitled to the column of airspace on the surface ad infinitum. So, every owner of a piece of land is entitled to the column of the airspace that is above his land to ad infinitum. And similarly, the ordinary rule of law is that he has got, if a site, it is the owner of everything up to the sky and down the center of earth. So, if he is the owner of a site, he has ownership on everything up to the sky and up to the center of earth. So, below and above both spaces he has absolute ownership. So, as nobody can enter through the subsoil of my land, it will be trespass, nobody can enter also above, it is a trespass. And when you are trying to enter above, it is called aerial trespass. So, an example of that is an advertising signboard erected by the defendant projected into the airspace above the plaintiff's single storied shop. In an action for a mandatory injunction to remove the signboard on the ground of trespass, the defendant alleged inter alia that the invasion of superincumbent airspace did not amount to trespass. It was held that the projection into plaintiff's airspace was a trespass and a proper case in which to grant mandatory injunction. Now, say this is my single storied shop and this is a multi-storied building of the defendant. So, this belongs to plaintiff, this belongs to defendant, and say this is a border, boundary, this side belongs to defendant. What defendant does is that defendant now from his 8th floor, he puts a signboard. And this signboard now covers the top portion of the house of the plaintiff, which is his shop. So, the plaintiff now files a suit for trespass and says injunction to immediately remove it. Defendant argues that above his land the superincumbent airspace. This superincumbent airspace does not belong to him. So, therefore, this is not a trespass because it is entering into the superincumbent airspace. Of course, it can be a case for nuisance, but it cannot be a case for trespass But the court rejected that and said projection into plaintiff's airspace is a trespass of a proper case for grant of mandatory injunction, and held that where the injury to the plaintiff is trivial, no injunction will be granted. However, because the injury was trivial nature, so no injunction will be granted. So, underground my right, above my right. However, there has been modification with aerial trespass rule. There are laws that have come which says that now like it is no more like up to the sky, there is a particular height, after that it belongs to the state and or the airspace belongs to the some kind of a common agreement, and based on that these helicopters or flights flying over my land is not trespassing. Then the next concept is continuing trespass. Now, continuing trespass means that every time a fresh trespass action is brought, it continues from the beginning. So, every continuance of a trespass is a fresh trespass. An action may be brought in respect of it. The continuing of a trespass from day to day is considered as a law separate trespass on each day. So, it is a separate trespass. Example, if a man throws a heap of stone or builds a wall or plants a post of rails on his neighbour's land and there leaves them, an action will lie against him for trespass, and the right to sue will continue from day to day till the encumbrance is removed. So, as I said, every right to action or cause of action, which we call cause of action, right to sue, has a limitation. But the continuing trespass rule says that if I have placed illegally without justification in somebody's land a heap of stone or place a rail or something, planted a post, then the defendants, then that other party's right to file in trespass will continue till the encumbrance is removed. Every day it is a new day and a new trespass. So, that is called continuing trespass. But there are exceptions to this rule. One exception is wrongful act amounts to outstore or disposition. We will discuss what is concept of outstore or disposition. So, a wrongful act amounts to outstore or disposition and the injury is complete on the date of outstore or disposition, and the resulting injury is committed on the date of outstore or disposition, right. So, when outstore or disposition happened, continuing trespass rule will break. So, on that day when the injury happened, on the day of outstore, before that trespass, the last date when the outstore or disposition happened will be the date, after that no trespass action, if it is proved that the outstore or disposition is appropriate and correct. If it is proved no, then the entire period the continuing trespass will continue. Third is trespass ab initio. When an entry authority or license is given to anyone by law and he abuses it, he becomes a trespasser ab initio. That is, the authority or justification is not only determined but treated as if it was never existed. His misconduct relates back to so as to make his original act as tortious. So, a police person had warrant to conduct search in my house. He conducted. Now, what he is to search, he knows. But what he did was, instead of searching all that or searching that, along with that he completely ravaged my house. He broke everything. Those acts, if it was not approved by the warrant, or he beat up my servants, then in that case it is an illegal search. And illegal search makes his illegality from the entry. If the search is turned to be illegal, his entry into the house from that time it is illegal. So, that is called trespass ab initio. So, from the moment he stepped into my house, though when he stepped in originally he had a rightful warrant, but because his subsequent act illegal, it turns his entry also illegal. So, that is why it is called trespass ab initio. The judgment of 1980 House of Lords is an interesting case decision on this point. So, car drivers had their own cars. They often went to London airport. They were in touch with hotels in central London. When passengers wanted a car to take him to the airport, the hotel telephoned one of these car drivers and he took the passenger to the airport. These car drivers then hung around the airport and sought to get passengers to hire them for a drive back to London. They thus got ahead of the licensed taxi drivers who are in the feeder parks awaiting to be hired. The court held once these car hire drivers pick up a passenger at London hotel and drives to the airport, he has a right to enter so as to drop the passenger and the luggage. But the driver has no right whatever to hang about there so as to tout for an entry fare, return fare. But so doing, he is abusing the right which was given to him by law, and that automatically makes his entry also a trespasser ab initio. So, what is happening is that there are some car drivers who are private taxi owners and they had arrangements with the hotels. So, they used to drop when the hotels used to call them passengers of the hotels to airport. Now, in this process, when they reach the airport, so this is the airport, they reach the airport, they used to drop the passenger. Now, as per the norms of the airport, this was a parking area and this was the entry of the airport entry gate and this is the exit gate. And the cars after dropping are supposed to come and stand in the parking, and once the passenger comes out, by queue they are supposed to pick up the passenger. But what these people used to do is that they used to take the alternative route and they used to go around and stand somewhere down here outside the parking lot and then touting for passengers who will come out from here directly to meet them. So, they used to stand here and directly tout. Now, this act was illegal because they were getting, violating the norms of the parking based, and the queue based, taxi picking system. Now, although their entry in the beginning was not illegal, but because of the subsequent act, their very entry was also made illegal. That is called trespass ab initio. So, because the subsequent act turns the whole transaction illegal, so their entry also, which was earlier legal, but now it has turned into a illegal act or what is called trespass ab initio. Now, coming to the concept of disposition, we saw that disposition acts as a defense against, or from the day of disposition the continuing trespass rule may be moderated. Now, what is disposition? Disposition means taking possession of a land from a rightful owner. So, of course, this is also a form of a trespass. But the question is, does all disposition is a trespass? No. There are certain defenses that are allowed when disposition happens, which are when the defendant has a better title than the plaintiff. When the defendant has a better title than the plaintiff and he has disposed the plaintiff, then he is not committing trespass. Secondly, there is a prescriptive right that if the defendant having held an immovable property or enjoyed the interest for 12 years or upward, the plaintiff's title has thereby extinguished and the defendant has acquired a good title. This is called prescriptive right. So, if the defendant was staying in that particular illegal immovable property or enjoying his interest for 12 or more years and the plaintiff did not object it. So, by prescription now defendant has better title than the plaintiff. So, initially he had dispossessed the plaintiff, but now by prescription he has a better title, so there is no disposition. So, in order to constitute disposition, there must be a positive act. So, when disposition is constituted, a positive act which can refer only to the intention of acquiring an exclusive control. Intention to acquire an exclusive control. So, one, a positive act has to be there. Second, an intention to acquiring an exclusive control. The true owner can be said to be dispossessed when the trespasser acquires settled possession. So, disposition happens when the trespasser acquires a settled possession. And determination of possession is whether the person who is called in question has a general control or not. What is the remedy for disposition? Party dispossessed can bring an action to recovery possession of the land. Now, we often see pavements in cities, areas surrounding the railway line, places below flyover. People have gone and started temporarily through some structure staying there. Now, this is a disposition, because that part of the land belongs to the government and anyone who is encroaching that is a trespasser. And it is justified because in Olegatile Supreme Court said that you do not call them as a trespassers, because they have not done this by choice but by compulsion. So, be sympathetic, but no court has allowed them to be any prescriptive right, because they were living there for a long time, but that did not acquire them as prescriptive right. So, and they did not had a settled possession. So, that is why they were been able to remove, and the removal has happened through the decision of court. So, an action to recover possession. So, action to recover possession, and when these two defences are not allowed. Of course, the second defence has not been allowed in most of the cases, because there are cases where this occupation has happened more than 12 years. But prescriptive rights cannot occur when courts have said prescriptive, when your very initial encroachment is illegal. Now, moving to the second part or second concept of right to trespass to property, which is movable property. Up to this point, whatever we are discussing was whatever trespass happened against immovable property, land, building, water tank, which are not movable, immovable. But similarly, trespass can happen against movable property also. Property is movable when it can be moved. For example, this pen is a movable property. It is attached to this. This is a structure which is attached. If the structure is fixed with the ground, then it becomes an immovable property. But if it is not fixed with the ground, then it is a movable property. Similarly, this is a movable property. So, this room is an immovable property, but the features that are present in this room, the chairs, this podium, this pen, this screen, they are all movable property, because they can be moved unless they are at that point of time fixed to the ground. They can be fixed to the ground. So, as we saw, trespass against land or immovable property in Roman law called trespass quaere causam fegit. Similarly, with immovable property, it is called trespass de bonis asperotatis. Trespass de bonis asperotatis, that is dependent's wrongful taking of goods or chattels of the plaintiff. Defendant's wrongful taking of the goods or chattels of the plaintiff. Now, what is trespass of movable property? I have parked my car outside. Somebody coming and snatching a mark on the body of the car, trespass. Okay? It is a direct act. Somebody leaving a dead body of a kitten inside the car or in the front of the car is a nuisance. But when somebody marks, similarly when somebody is removing a motor car tire, it is a trespass. Snatching on the panel coach, which I said, it is a trespass. Now, taking of the car is not necessary, the tube is not necessary, tire is not necessary. He opens the tire and leaves it there, that is also is committed the trespass. So, what are the essentials of trespass to goods? The essential elements are plaintiff must at the time the trespass have possession of the goods. So, when the plaintiff is claiming that there has been a trespass to goods, he must have the possession of the goods. And it is not ownership. So, you can commit trespass to goods against your own goods if the goods that you are claiming is not in your possession but in somebody's possession. So, things like trespass to goods, conversion or in crime theft, they are offences against possession and not ownership. So, what is possession and what is ownership? Possession means those who have immediate control. Ownership means who has the right over that part. I have a house, it is my ownership. I may have given rent. So, the tenant has the possession because I am not living house, it is not in my possession. I have a constructive possession, but actual possession is with the tenant. So, it is not important who is owner of the good, it is important who has a possession. So, plaintiff has a possession of the good. The possession can be actual or constructive or immediate legal right or to the immediate possession. That means I may have direct control, I may have control through my agent or servant or representative. So, when a house is in control of my servant, I am holding it. It is called constructive possession. Second, the defendant must cause unlawful disturbance of the possession of the goods. Unlawful disturbance of the possession of the goods by seizure or removal or by direct act causing damage to the goods. So, the defendant must unlawful disturbance of the possession of the goods by seizure or removal or by direct act causing damage to the goods. However, proof of actual damage is not necessary because it is a trespass. So, because it is a trespass, proof of actual damage is not necessary. Now, I will give you some examples. What is trespass to goods? Now, this is a 1948 English case, Humps versus Derby, very significant judgment which is cited by almost all the commentators who have written on law of torts with reference to trespass to goods. Now, in this case, plaintiff was the owner of certain homing and racing pigeons, released them for exercise and they alighted on the defendant's land and fed on his going peas. To protect the peas, defendant shot at the birds, killing 4 and wounding 1. In an action by plaintiff for damages for destruction of the injury to the pigeons, the defendant contended that there could be no property in homing pigeons, and even assuming that there could be such property, the destruction or wounding of the plaintiff's bird was justified. Now, court, so what happened? I will explain in simple words, because this is an old case, so the language is slightly old English language, old style of English language, so it may be little complicated. So, let me just make it little simple in terms of its language. So, the plaintiff was owner of some good number of pigeons, and these pigeons were homed and domesticated by him, and they were racing pigeons. So, pigeon race used to happen, and these pigeons every day for their exercise, because they were racing pigeons, they have to be kept on very agile, were left by the plaintiff, released by the plaintiff for exercise, and then they used to come back. Now, on that particular day they alighted to the land of the defendant, and then they ate his peas, right. That itself can be a case for trespass. But the defendant in protection, again he can claim private defense also. The defendant is protection fired, but proportionality is in question in private defense. To remove pigeons, do you need to fire a shot which kills 4 and wounded and make 1 wounded? A proportionality of the action. Now, those homing pigeons, 5 got damaged and the plaintiff filed a suit. Now, the defendant's action was, defendant contested this by first saying that in homing pigeons nobody has any proprietary rights, because pigeons are pigeons, they can fly anywhere. How can you say that they are your, because they may not come back. And second, what is called is that he has certain justifications, as I said, plaintiff was the wrongdoer, or right of private defense. So, these justifications could be taken by the defendant. Now, what did the court held here? The court held so long as the birds retain their animus revertendi. Animus revertendi means that when animals which are domesticated, they are released, after the whole day or whatever time they will come back to their homes, and in wild they will come back to their nest. This is a nature or phenomena of the law of God. So, animus revertendi. So, the plaintiff could claim a special property in them because appropriate from our action for him to take in respect of their destruction or wounding being trespass to goods. That there was evidence to support that finding the defendant has failed to prove that there were no practicable means other than shooting or stopping the birds doing damage to this crop, that he had acted reasonably in regarding to shooting necessary. So, therefore, whether wrongdoer or with the question of private defense, the defendant has failed, that there was other reasonable steps which he could have taken before opting to shoot, to remove the birds from his field. So, proportionality, right. But because of this animus revertendi, that is animals come back, in this case it was considered that the plaintiff has a right for the property, claiming this property under trespass to goods, because it is his right. Now, in another case, the defendant without leave quarried on the land of the plaintiff and removed large quantity of stone therefrom. So, first he entered subsoil and then he quarried stone. Held the plaintiff was entitled to recovery by way of damages the value of the stone after it was quarried, and that the defendant were not entitled to deduction therefrom of the cost they had incurred for quarrying the stone. So, stones when cut from the rock is no more a immovable property, and therefore it comes under trespass to goods. Now, what is conversion? Conversion is a willful interference without lawful justification to any chattel. For example, a auctioneer is liable for conversion even though he honestly believes that the goods belong to the seller and not to the plaintiff. He is liable for conversion. Now, how conversion and trespass to goods is different? Now, trespass is essentially a wrong to actual possessor and therefore cannot be committed by a person in possession. Conversion, on the other hand, is a wrong to the person entitled to immediate possession. So, conversion is against the entitled to immediate possession. to damage or meddle with the chattel of another, but without intending to exercise an adverse possession over it. Conversion is a breach made adversely in a continuity of the owner's dominion over the goods without hurting the goods. And last, trespass is the force and direct injury, conversion is deprivation of goods or their use. So, what I do is that, my first example, I have a orchard with juicy mangoes hanging from that. X, who is my neighbor, he enters my land, stays there. Okay. Now, mangoes when hanging from the tree is immovable. Now, he removes them, he plucks them. Now, it has become movable property. So, he commits first trespass to land by entering into my land. Then he commits trespass to goods by removing them, and then he commits conversion by taking it with him. So, all three. Okay? And therefore, conversion and trespass to good is, the moment you proc that, it is trespass to goods. The moment you take it away, it is conversion. So, conversion is a breach made adversely in the continuity of the owner's dominion over the goods without hurting the goods. Now, he does not hurt the mango, but he keeps it with him. Okay. So, the justifications for trespass are leave license. When I am justified to be a trespasser, leave license is a form of an agreement. So, I have given permission, leave license. Expulsion of the trespasser, another trespasser has come, for example, that pigeon, if he had taken some other means to remove without shooting, which was proportional, then it would have been justified because expulsion of trespasser. Retaking of goods, I entered to retake the goods. Lawful correction, I do some act which is necessary, which may render me to trespass, but it is basically for a lawful correction of somebody. So, basically nuisance has happened. So, somebody's trees are overhanging my garden. So, I enter into his land to cut those branches. Entering the land is trespass, but for a lawful correction to avoid the nuisance. Preservation of public peace, when police enters my house, always it is not necessary he has legal authority, but he has a legal authority overarching because preservation of public peace and statutory authority. And he is authorized by the statute, if he requires he can enter. So, these are the justifications which a person can give specifically apart from the general justifications in case of trespass. So, thank you for being part of this discussion. Next, after this we move to the another very important class of tortious wrong, which is against reputation. Individual's reputation is very, very important. So, against reputation, trespass, negligence, nuisance was largely body property, but the wrong against somebody's reputation can be equally harmful, and that is defamation. So, in my next lecture we will discuss about defamation. Till then, thank you very much, and I hope you are enjoying this lecture. So, thank you for joining this lecture with me. Thank you.